Welcome to Pride in Parsippany. I'm your host, Mayor James Barberio, and today I have with me the Morris County Surrogate, John Pecoraro. Welcome to the show, John.
Nice to see you. Nice to see you, Mayor.
And as many know, I always give a mug near the end of the show, but it was a little warm in here, so I put some water in it, and he got his mug.
I got to appreciate drinking it right away.
Exactly.
I don't have to wait.
And the water's cold.
Yeah, it's excellent.
Can you explain to the residents of Parsippany what a surrogate is and what a surrogate does?
Yeah, basically, a surrogate is it's not really descriptive, highly descriptive what the office is, but the title is a very, very old title. It's a title the state of New Jersey uses for its probate judge. I'm served as the judge of the surrogate court, and so does New York. New York has surrogates, and it's a very old English term. A long time ago, when the King and Queen of England owned the state of New Jersey, it was a royal colony, they designated the governor of New Jersey to be their surrogate in their place when land had to be divided up. And then when he sent deputies out all across the state as the state got more and more populated, we took on that particular term in place of, and actually means in place of, in this case, the governor of New Jersey, and who was the surrogate in place of the King and Queen of England. And then when we became under the Constitution of the United States, that term stuck, and with the constitutions of the state of New Jersey, the surrogate is now really under the judiciary branch of the state of New Jersey, and we serve as the judges of the surrogate court.
Oh, okay. How long have you been the surrogate? I mean, I know...
1994.
Yeah,
1994 I was elected, appointed initially by the governor, who, because the surrogate at that point had left. Gene Doyle was the surrogate, and he retired. And so the governor needed to make an appointment. But that appointment was only good for the remainder of the year. So then I had to run in the election, and surrogates are the only elected judges in the state of New Jersey. There's every county has a surrogate, and each one of us gets elected, which I like. I like.
Yeah, and the rest of the judges are appointed by the governor. Before I get into my experience I had with you,
okay.
What is meant by probating wills?
Yeah, a probating will. Probate. Just think about the word probate.
Right.
If a judge of the surrogate court is making sure everything is properly done when the will is presented for probate, that it gets approved by the court. So there's a lot of P's involved in probate. So it's properly done. It gets approved by the court. When does it actually happen? It occurs when someone dies and they leave assets in their name alone. So you go to the bank and you say, listen, my husband died. He has a bank account only in his name, and I'd like to have access to it. You can't have a touch to that. It's in his name. He's dead. Have him sign the documents, and then we'll give it. He can't. He's dead. So basically, anytime there's assets in the name of a deceased person, the person who wants to claim access to those assets presents a will to the probate court, and then we make sure everything's properly done. Everybody in the family that has a vested interest in it approves that it's okay, and then I sign the judgment to appoint the executor so they could speak for those assets after death.
So basically, if there is no will, there's a problem.
Well, yeah, basically, I say to people, how many people have actually decided to leave all of their assets to the state of New Jersey after they die? And I don't think anybody ever really takes that question seriously. They laugh. And that's very hard to do, It's very hard to leave your assets to the state of New Jersey. It has to be no blood relatives alive. Right. Only in-laws. And in-laws, if there's no will, are outlaws. You can't leave money to an in-law unless you put him in the will. But if someone dies without a will, and let's jump to that right away, and then we'll go back to really how to make a proper will. If someone dies without a will, right now in the surrogate court, I could ask this question. This is going on right now. How many people have actually decided to leave a chunk of their money to someone that they wouldn't give a dime to today if they were alive? Mm. And that does happen if you die. That can happen if you die without a will. If you have assets in your name, the will actually, there is that the statutes of the state of New Jersey come to play. They become your will. That becomes your will. And there's a natural process about who's entitled. The closest blood relative could get your money, even though you may not have seen that closest blood relative for the last 25 years of your life. So it's very important to write will. I think that's become pretty obvious to me in the 20 plus years now I've been a surrogate.
So if you're doing a will, what should you have with you? I mean, what should you bring with you, or probating a will?
Well, first of all, let's talk about what should be in the will when someone writes one. When someone writes a will, they should make sure that there's certain components in that will that are going to become very important to the people involved who are going to get the assets and to the court itself. When a will is done, it should have a section in which how your assets need to be divided. It could be a paragraph. It could go on for pages. It's all according to how complicated you want your will to be. Second of all, it should have a spot that says who the executor is. Who do you want to be the quarterback to hand off all the assets to the beneficiaries? Who do you have the most confidence in? Who do you have the most trust in? It should have an alternate to that executor, should that executor not be able to serve. First of all, you can't have more than one executor also. But then you should have an alternate in case that person cannot serve. If you put a trust in your will, and that is a trust that says, it doesn't exist right now while I'm alive, but upon my death, I want this trust established. If you put that in there and describe how it is, and a good attorney that writes wills knows how to do that, and for the reason, there's certain reasons why you might want to do that, sometimes for tax purposes. You should identify who the trustee is in your will. The executor you named in the will is not necessarily the trustee, unless you say so.
Right.
Then put an alternate to the trust. Sign the will. It's very important that the will be signed and witnessed by two witnesses. Two witnesses, not just one. And then on that will could be presented to the surrogate court for probate.
Have the laws, I know I will tell you, when my father passed away, I came to you, and you were very, I don't know if you remember, it was 2002, we did speak, but you were great.
Oh,
Not only were you helped me out, but you all were comforting, and that's more important because
that's important. I'm glad you said that.
Yeah, you were very comforting because I wasn't confused, but I was close to my father.
Sure.
Like my sisters and I were all very close to my father, and when he passed away, we know we had to do things, but we just didn't have the strength. But you guided me through. You were awesome. I mean, you not only you taught things, you talked to me about my father, about my relationship with my father. And you were spectacular, and I will never forget. And this is I say this for a reason, because if this ever happens to anybody, this is the right guy. He'll guide you perfectly.
Well, I leave instructions to my office that, listen, when someone comes into the surrogate court, they're coming in at some of the most vulnerable time of their life. Someone died in their family. Right. So if you're having a bad day, or if your coffee didn't taste right that morning, or you have an extra piece of paper that you have to take care of, the person on the other side of in the surrogate court actually has the real problem, number one. Number two, probate is a confusing process. That's why I talk about this as my coming to talk to people on a show like this or different groups to lift the mystery from surrogate court. Why should anybody really know what's going on a probate court? If they really know what to do in probate court on a regular basis, that means people are dying around them all the time,
really.
And which is a very, 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 very sad thing to happen, which has happened to people. I've been in there several times on different family members. So I tell people try to be as caring as possible, and let's try to use the probate law as best as we can to say yes. To yes, we can move forward. Yes, we can get that thing done. There's certain things that are presented to the surrogate court that we may not be able to overcome. But if we can, let's move forward and try to help people through the process and explain it to them so that they get some idea of what happened while they were sitting there. They don't have to really remember it a month later, but if we can try to do the best we can while they're there, I really think that that's a good idea.
Is it, I mean, some people can't afford it. I don't know if it's expensive. Is it necessary to get an attorney?
I do believe it's a good idea to get an attorney or a very skilled professional to write your will. Okay, that I think, because things are so nuanced that when I first became a surrogate, I thought perhaps maybe that wasn't important, but I've seen a lot of people make the most expensive wills by writing them themselves. Yeah. Okay, I'll get into that in a second. Yes, I think it's a good idea because the laws do change. For instance, in 1978, Remember I said you had to have 2 witnesses?
Yeah.
Well, in probate court up to 1978, you had to bring one of those witnesses in. What happens if you wrote that will 20 years ago and you don't know where the witnesses are anymore, or they died on you?
Right.
Well, in 1978, the law was changed. It said those 2 witnesses could sign an additional document that said that they saw you sign the will under no duress of sound mind, over the age of 18, and under no due influence. And they signed that statement before a notary in the same time and place that you're preparing the will. That gets attached to the will, and it's called a self-proving will. Now, the surrogate court does not have to say to you, oh, by the way, executor that's coming in to probate someone's will, go find me a witness. The self-proving statement is already there. Why? When a witness does have to come in, on some rare occasions when the will isn't self-proving, what are we going to ask them to sign? We're going to ask them to sign a document that said that the person who died, the testator who signed the will under no duress of sound mind, over the age of 18, and under no due influence. So instead of waiting years later to sign that self-proving statement, they're doing it the very same day that they're preparing the will and attaching it. And it's made it so much simpler to probate that will. Sometimes someone comes in and they could have the will probated either that same day or within maybe a week, no more than a week if my staff is a little busy. Within a week, I'm signing the judgment and sending it out, and the person is getting their surrogate certificates in order to be able to go do what they really need to do. And we try to make this so much easier.
Morris County hands out a free booklet. Am I correct?
Mm-hmm. Yeah.
Should you think it's necessary to obtain one prior to coming?
It's not a bad idea. It's people have I have one right here.
Oh, all right.
Okay, it's a citizen's guide to wills, trusts, and estates, and anyone can call my office, and we'll send you a copy. 973-285-6500. 973-285-6500. They can call my office and we would send them one. It has some very good information about preparing the will and also what to do once you come to probate court, including making an appointment. We like when people make an appointment to come in.
That's right.
Yeah.
What's a minor intermingled trust fund?
Oh, okay. The surrogate court has really 2 major functions. One is, I just described to you, when someone dies, and they have a will probated. The other thing is I serve as the judge of the court to appoint a guardian for minors. Anybody below the age of 18 who comes into money, however way they come into money, if their grandfather left them something, or if their parents died and they come into the money, if they slip and fall on the sidewalk and their parents go to court and the child is awarded money, that's the child's money, not the parents' money. So I have to appoint a guardian for those assets. It usually, many times, it's the parents, but if there are no parents, I have to then go to brothers and sisters or grandparents or some down the bloodline till we can get a guardian. But that money comes to the surrogate fund, the minors intermingled trust fund. And I have about $26 million worth of money. Bankers like to deal with the surrogate court of Morris County, surrogate court of any county.
And when they hit adult age of 18, then
they come collect it.
I see.
Yes.
Okay. I didn't know this until I got the question myself. The happiest part of the surrogate court is adoptions?
Yeah, adoptions. I don't serve as the judge of the adoption court, but I got a lot of titles.
Right.
I'm the surrogate, I'm the judge of the court, I'm a constitutional officer, and I'm also a deputy clerk to Superior Court. And that's one of the times I am. How do I serve as a deputy clerk of Superior Court? All the papers that all the attorneys on both sides gets filed with the surrogate court. Assigning an agency to go out and investigate the household is done by the surrogate court. The report comes to us. Then once all that particular documents are in our possession, then we schedule a hearing for a Superior Court judge who then does the final adoption.
Right.
But a good chunk of the work is done in my office.
Wow.
So we got several different roles to the surrogate.
So if a family member passes away, what would you say the time frame is to come in?
Well, first of all, people could come in at any time. The biggest question is how late, when is the cutoff date? There is really no cutoff date. People have come in 15 years later. Oh, I'm living in my grandmother's house, and we went to go sell it, and nobody's ever probated my grandmother's will, and she died 15 years ago. So there is no time frame.
Right.
But it's good to do it in a quickest, Mayor, you're going to find out very quickly. The first institution a person goes to that they can't get access to the assets.
Right.
The first time they try to sell a house, the first time they go to the bank, they'll find out quickly.
Right.
You better go. You need a surrogate certificate to tell us that you are indeed the person in charge of the estate. When it's usually, so they bring the will in, and we probate that will, and we appoint an executor, and they move forward. If they come without a will, there's still a way to be appointed. Now you're called an administrator. There's a way to get there. It's a little more complicated, can be more expensive, because sometimes we have to bond the administrator. Sometimes it gets so complicated that it can't be done in surrogate court. Once you have to go to Superior Court to get anything done, then it becomes very expensive, because the attorney's fees at $400 an hour can drive a probate even of a basic will, if it can't be done in surrogate court, to several $1,000s instead of the 100, but less than 200 it's usually done in Superior Court, in surrogate's court.
So it's advisable to get a power of attorney? I mean,
power of attorney is good, but power of attorney ends with death. So it's not good beyond death. Power of attorney is only good when someone is still alive.
I didn't know that.
Because a power of attorney is supposed to be something that you could take back, and you can't take it back if you die. So it ends with death.
Right.
A lot of people will say, why do I need to come in and probate? I'm a power of attorney for my father. But you just said your father died. I said, yeah, my father died. Well, once you say the person is dead, the power of attorney ended. So anybody you present the power of attorney to, if they know the person is dead, it's no longer active.
I was power of attorney for my father, but I was also executor.
And the new power of attorney after death was the probating of the will. Right, if you want to think of it that way.
All right.
Okay, so it's I think an important fundamental step. We do not make probate difficult in the state of New Jersey, but it's an important step. I do believe that necessary, just to look into the matter to make sure that everybody's agreeing that what's going forward. Because if there's a disagreement, if there's a controversy, if it's writing on the will that I can't understand what happened, it causes the surrogate court doubt and difficulty, I must send it to Superior Court. And at Superior Court, then it becomes more complicated. People show up and they have to, testimony has to be taken, and that's when the attorneys make their money.
Is there a charge for the service, for surrogate?
Yeah, it's by statute. It's usually less than $200, usually. Unless there's a very lengthy will, there's a lot of trusts. But basically, the fee that somebody has to, I'm not including the attorney's fee if you bring the attorney with you. That's a separate fee that they get.
That's
what
on
the
them,
court
right?
gets, is usually less than $200. The surrogate court.
Well, the big topic today, and I know we talk about taxes, but inheritance tax.
Yeah, inheritance taxes are awful. I mean, basically, the federal government started to move away from inheritance taxes back in 2001 when George W. became president of the United States. Congress and the president said, the death taxes can be onerous and surprising, so they started to move away. Because the threshold of anybody's estate for the federal estate tax was $600,000. And there was a New Jersey estate tax also, and they coupled it. They said whatever the threshold of federal government, the state of New Jersey will have the same threshold. Well, the federal government went to $650, then to $675. So did the state of New Jersey. Then the federal government went to $1 million. Now it's $10 million. No, I think it's $5 million per person. So it can be, you can double it from spouse to spouse, can make it $10 million by transferring it upon the death of the first one. So let's say it's $5 million, I do believe, the threshold. State of New Jersey stayed at 675, which is really what they're trying to work on, getting that threshold back to couple it in with the federal government threshold, or removing it totally. That's what the big issue is today, because that's the way it used to be. Once you make a threshold like $5 million, most of the people in the state of New Jersey won't be affected by it. Then there's another death tax the state of New Jersey has, called the inheritance tax. That's not based upon how much it is, that's based on who you are. It's a little less burdensome because if you're a spouse, a child, a parent, a grandparent or grandchild, or a stepchild, there is no inheritance tax.
Oh, I see.
Okay, so it's for brothers and sisters,
Right.
Friends and cousins. So it's not too much of a burden on a vertical family, the family that has the children and the grandchildren, or or parents or grandparents still alive, getting the money. The state tax, however, that's one that's driving people out of the state of New Jersey. There are people that make a lot of money each year, that we collect a lot of income taxes each year. To get their death tax when they die, we lost all of their income tax because now they've established residency in another state.
Right.
They're moving the whole businesses out because of that.
Right, and I know that guy, I forget his name, $140 million we're losing just on one individual.
Yeah, on one individual. I mean,
Wow.
So everybody understands that the death tax, the estate tax of the state of New Jersey has to be changed. It's a burdensome, onerous task. It was the decoupling, making it not the same as the federal threshold, happened in 2002 under McGreevey. I called a bunch of the legislators at the time, the assemblymen and the state senators at the time, and we had a press conference to say, listen, this is going to cost us millions and billions of dollars. And media at the time didn't even understand what we were talking about. Now people understand after they look back and say, now we've lost $20 billion on that one mistake.
Wow. Anyway, you were very informative tonight, John.
Okay.
Today, John. So I want to thank you for being
You're
on
welcome.
the show. And ladies and gentlemen, thank you once again for tuning in to Pride in Parsippany. And God bless you all.